All rise. You may be seated. All right, so we're back on the record. You may pick up, I believe, exhibit number 134.
Thank you, Your Honor. Exhibit number 134, Dr. Brickhouse, is that there in front of you?
Yes.
All right. And what, if anything, does that document about the defendant's transfer back to general population in January 2012?
There should be a second page to this.
There is. Well, then let me look for it. Do you recall the defendant? You were telling the jury being transferred back to general population in January 2012.
Yes, Mr. Newman and I spoke. He had been on the unit for 3 months. Based on what was in his medical chart, notes from the nurses, my conversations with him, observations, we were all in agreement that there was no reason for him to stay there any longer. And he felt as if he was going to be able to manage general population better than before. So I documented that, which is what this document is. Patient has been housed on 3A for observational purposes since October 14th, 2011, secondary to a sick call slip submitted by the patient and some statement he made about concerns related to potential self-harm.
Dr. Brickhouse, does that document and the page 2 that I'll get for you, does that summarize your observations of the defendant and then the action you took after that evaluation period?
It does.
Okay.
It's SOAP. We call it a SOAP note, but the S is the subjective, the O is the observation, the A is the assessment, and the P is the plan. So the observations that occurred that I document speak to the fact that for the 3 months that he was on the unit, there have been no complaints expressed by the patient. He has been observed by this examiner, nursing staff assigned to the unit, and DKSO officers assigned to the unit to be conforming to the daily routine without incident. He has taken care of his personal hygiene. He's had access to visits. He's had access to commissary items. He's had access to any requested medical care, and he's had access to express his religious rights and beliefs, and he's had access to phone privileges. Overall, the patient and assigned staff have implemented the plan protocol written on October 18th and adhered to the instructions.
Dr. Brickhouse, Your Honor, may I approach?
You may.
And with the court's permission and after speaking to the land, I'd like to substitute State's Exhibit number 134 for the new State's Exhibit 134 that has the back page, the second page that the doctor referred to.
So refer to that as 134B or 134A.
Yes, sir, I will mark it as.
Already and identify for the purpose of the record.
Yes, sir, I'm going to mark that as 134A, and that's the two-sided page document. Thank you, Dr. Brickhouse.
Any objection to 134A, Mr. Land?
No.
All right. 134A will be admitted without objection, and based on your presentation, that has it's a two-sided document.
Yes, sir. Thank you, Your Honor. I apologize.
No problem.
Dr. Brickhouse, shortly after January 2012, do you recall the approximate date that the defendant was transferred to a different facility outside the DeKalb County Jail? Was it months, weeks afterwards? If you recall.
When you say transferred outside,
Yes.
It was months.
Months later?
Yes.
Okay.
Or
Did you have
months.
any other interaction with the defendant in 2012 while he was there at the DeKalb County Jail that you recall?
After he was released from 3A, no.
Okay. Did there come a time when the defendant was returned to the DeKalb County Jail?
Yes.
And do you recall approximately when that was?
Oh. To be honest, no, I don't remember exactly.
All right. Do you recall sometime after 2012, at some point the defendant was returned to the DeKalb County Jail, did you have any interaction with him at all?
I have not, other than 2 brief meetings. I know that once he did return, he was subject to the same intake screening review that we do for all new admissions.
Okay. And did the defendant return to the DeKalb County Jail on any sort of medication?
Yes, he did.
Okay. And do you recall what that medication was or what it was for?
If I remember correctly, it's Depakote and Remeron.
All right. And did the medical records at the time the defendant re-entered the DeKalb County Jail, at that time, what was he taking that medication for? Do you recall? If there's a diagnosis, do you know it?
No, I don't.
All right. Have you had an opportunity to observe the defendant since he returned to the DeKalb County Jail?
Yes.
Have you had the opportunity to observe the defendant since he's been on this medication?
Yes.
What on this medication?
Yes.
What, if any, difference have you seen in the defendant's behavior from when he's now on medication and before when you observed him when he was not?
In my view, there's no difference.
There's no difference in his behavior?
No.
What about symptoms of mental illness? Do you see any difference in any symptoms in mental illness?
No.
Did you see any before when he was in the DeKalb County Jail prior to 2012?
No.
You see any now?
No.
Anytime that you've ever had any interaction with him or in any medical records that you've reviewed, have you ever seen the defendant exhibit any signs or symptoms of mental illness?
No.
To your assessment that the defendant does not suffer from any mental illness, has that changed at all, given the fact that he's on medication now?
No.
Dr. Brickhouse, are you being compensated for your time here this afternoon?
No.
No. Are you an employee, or were you hired by the state to come testify?
No.
And you didn't do a forensic evaluation on this defendant, correct?
Correct.
The questions you've answered today are based on your personal observations and your interaction with the defendant, is that right?
Yes.
Okay. And were you compensated for your time involving Mr. Neuman in any way other than the regular salary that you receive?
No.
All right. Thank you, Dr. Brickhouse. I don't have any other questions.
Mr. Land, you may examine the case.
Thank you, Judge. Good afternoon, Dr. Brickhouse.
Good afternoon.
You said you're the director of mental health at the jail, correct?
Yes.
And you talked about, before the break, you talked about the intake screening that's done for everybody that comes into the jail as an inmate, correct?
Yes.
But then there's a follow-up that you did with Hemy Neuman, and that's not necessarily done with every inmate, correct?
Correct.
In October of 2011, you went to see him at his request, right?
Yes.
And you thought that the discussion was about his housing, right?
Yes.
Or was going to be about his housing. You're not in charge of housing at the jail, right? For just the general population of the jail?
No, I'm not in charge of housing.
When you spoke, the times that you spoke with Hemy Neuman, and I think that Ms. Cross asked you this question, but I'm not sure you actually answered it, you didn't discuss the actual facts of his case, did you?
I'm not sure how to answer that.
Okay. Well, did you discuss with him his relationship with Andrea Sneiderman?
No.
Did you discuss with him, you said there was no mention to you of any demons or hallucinations, correct?
Correct.
Did you discuss with him Andrea Sneiderman's children?
No.
Did you discuss with him the business travel he took with Andrea Sneiderman?
No.
Did he discuss with you the development of their relationship?
No.
Did he discuss with you any poems that he wrote her?
No.
Did he tell you that he believed her children to be his children?
No.
Did he tell you about shooting Rusty Sneiderman?
He referenced it.
Did he tell you the specifics?
No.
Did he tell you about the disguise?
Not explicitly, no.
Did he tell you about renting a van?
No.
Did he tell you about going into work early that morning?
No.
When you talk about your opinion about his mental state, you're talking about the times that you were able to observe him, right?
Yes.
So from January 2011 till whenever he was transferred to the other facility, and then since he's been back in the jail, right?
Yes.
You've not formed an opinion or been asked to render an opinion about his state of mind on November 11th, 2010, correct?
Correct.
And I think you just said on direct examination that you were never asked to conduct a forensic evaluation, correct?
Correct.
You talked about medication that he was prescribed at the other facility and that he is continuing to take, correct?
Correct.
And he's taking that at the DeKalb County Jail, correct?
Correct.
And you're a psychologist, right? So you don't actually prescribe medication?
Correct.
But since you're the director of mental health, you oversee the psychiatrists who do prescribe the medication, correct? At some point, do you recall, some point this year, do you recall getting an email from Mr. Newman's attorney asking you to check on his medication levels?
I can't deny getting the email. What I can say is we have a continuity of care policy, so once he returned to the facility on medication, we've continued him on that medication.
Okay. If I showed you the emails, would that help refresh your memory about them?
Yeah.
Lawyers approach.
May I approach the witness?
You may approach.
Just to refresh your memory, Dr. Brickhouse, can you just read that to yourself? And I've handed it to you with the initial email and then going forward to your response.
Okay. Okay.
And then a second email with a follow-up email that you sent.
Okay. Okay.
Does that refresh your memory about the email?
Yes.
Or emails? And so now do you recall receiving an email expressing concern about his medication levels?
Yes.
And in fact, you followed up on that, right?
Yes.
And you had his levels checked, correct?
Yes.
And you responded that the levels had been, were fine based on the review, right?
Yes.
But that it was discovered that he'd been off of one of his medications at some point during the days.
Apparently he missed a morning dose, that's what.
And that was an error, correct?
Yes. Well, it shouldn't have happened, but.
That is all I have. Thank you, Dr. Cortez.
Any redirect?
Yes, Your Honor.
You may.
Dr. Brickhouse, you use the phrase continuity of care. What do you mean when you say continuity of care?
It's one of the standards. Translated, if you're on the street at noontime and you're on certain medication and you come to jail, our obligation is to take a look at that and continue that treatment, whether we agree with it or not.
All right. Anybody at the jail diagnose the defendant as having bipolar disorder?
The answer is no.
Okay. Thank you, Dr. Brickhouse.
Just thank you. No more questions.
Yes, Your Honor. I'm sorry, no more questions.
That's fine. Any recalls? Lawyers may as witness be released and excused from the subpoena. Do you want him to remain on subpoena?
He may be released from the state, Your Honor.
Any objection?
No, Judge.
All right, Dr. Brickhouse, you are free to go. Have a good afternoon, Johnson.
Thank you.
Let's see you. All right, next witness, please.
You're on state of Georgia arrest.
All right. All right, ladies and gentlemen, at this point in time, the state of Georgia has rested. Lawyers, approach this briefly. All right, Kelly, we're back on the record. All right, ladies and gentlemen, the state has arrested its rebuttal part of the case. The next portion, the defense had an opportunity to put on what is called surrebuttal. But because of the scheduling challenge, unrelated to you, I'm going to have to go ahead and end this for right now, for today. When I say end, testimony we're paused at this point. End was not a good term. Pause in the case for right now. Just hitting the pause button. And I'm going to get with the Assistant Deputy Garrett end up with I'm going to let him give you the instruction. As I mentioned to you at the beginning of the case, because sometimes for planning purposes, I have another court matter scheduled for tomorrow, unrelated to you. But you won't be in session with me tomorrow, but I will be here. You're more than welcome to stop by and say hello, but you don't have to come, not for this, but I will be here all day tomorrow. But you'd be more than welcome, unrelated, if you just want to say, hey, how you doing? But when I release you for this evening, that discuss the case, I'll allow anyone to discuss the case with you. You're not sitting next to anyone. All I want you to sit next to you in a restaurant or any other facility. You may or may not be discussing the case. You got two options: either A, move away from them, or B, tell them to move away from you. Do not remain upon the 5th floor once I release you for today. I don't want you to hear or say anything you should not hear. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog or write about this case while it's ongoing. Do not go to any location that may or may not have been made reference to. All the evidence will come to you in the form of sworn testimony from his witness stand and any evidence that's introduced during the course of the trial. You're more than welcome to bring something to snack and I'll eat with you during the sessions. Do not consume any alcoholic beverages during lunch. If you do decide to have alcoholic beverages in the evening, do not consume too much alcohol that will impact your ability to come back to court the next day. At this point in time, the lawyer still cannot talk and interact with you outside of the presence of the court. And that is, I'll be giving you no standard instructions, but I don't want you to draw anything from that one way or the other. As I said, we're going to hit pause, but we're not interact with you until Friday morning. And we'll resume, we're still on the presentation of evidence, and we'll resume that portion of the case on Friday at 9 o'clock a.m. I know it came up last week, can you go to work? My preference is for you not to. It's just that, as I said, in these lengthy matters, I try to give you time so that if you had to, I'm not saying you will, but if you had to make a doctor's appointment or reschedule an appointment for you, your significant other, your child, or someone else, you could have done that on that Thursday, dental appointments, doctor's appointments, things like that. Because it's sort of difficult for me to ask someone to give up the whole month. I'm not saying this would be the whole month, but just an impossibility. So I built that into the schedule. But as I indicated earlier, last week, when I was giving you the same instructions last Wednesday, and obviously if you're in a situation where and I'm perfectly not go to work because I don't want you to be around people you're so familiar with, they may or may not ask you a direct question, and I want you to engage in a conversation at this point in time with anyone about the case. So that's one reason I said my purpose would be not to go into the office unless you just have to do something, but do not discuss the case. I'll allow them to discuss the case with you. Now, we're still involved in the case. I'm just giving you a recess until Friday morning. You've been great up to this point. Everyone's been relatively on time. Everyone relatively been turned off their phones, so they won't be vibrating. But it's been great. Everybody's been on time. So what I'm going to do, let you go a little early today, so no one has to make any phone calls other than that the guests going to give you phones, and you can make whatever calls you need and make whatever arrangements you need. Now, leave your notepads there. The jury's going to face down. If you need additional notepads, they will be provided for you. Continue to wear your badges. I will see you Friday, 9 o'clock a.m. You can be early, but you can't be late. Have a wonderful day and a half away from me. Okay? I'll see you Friday morning, 9 o'clock a.m. Lawyers approach. 9 o'clock Friday morning. Thank you for having a positive attitude. Thank you for being on time. Thank you for continuing that positive attitude. Keeping an open mind. Good seeing all of you, and you've been great. I see all of you on Friday. All right, Deputy Garrett and Deputy Lewis, Deputy Garrett Lewis, we are in recess until, we're going to be in court tomorrow, unrelated to this at 9 o'clock, but we're in recess until Friday on this case, but tomorrow we'll be back.
All rise.